So I think we'll get started. So I wanted to welcome everyone here today. I'm Leslie Kraut. I'm one of our social workers on staff at Common Point, Queens. I'm also the director of our Single Parent Initiative. We're very pleased to welcome you here today, where we are conducting the second part of our employment law series. Today's topic is understanding your rights in the workplace while pregnant and parenting. And we're pleased to have 4 panelists today as our speakers. We have Alex Berke, an attorney at Berke-Weiss Law Firm. We have Laurie Berke-Weiss at Berke-Weiss Law Firm. We have Ina Plotsky of Counsel at Berke-Weiss Law Firm. And we have Astrid Reyes, a legal fellow at A Better Balance. So we invite everyone to put questions in the Q&A section, and there'll be time afterwards to have your questions answered. So now I'm going to turn it over to our presenters.
Thank you, Leslie. I'm here today just to kick off this program and to say we're here to discuss some really important and timely, complicated legal issues. Our goal today is to provide useful information to our audience at a high level and to really educate you on the resources that are available to address these issues through nonprofit organizations like A Better Balance, which is where Astrid is, through private law firms like Berke-Weiss Law, and through government agencies like the Equal Employment Opportunity Commission, New York City Commission on Human Rights, the New York State Division of Human Rights. This presentation is going to start with a dialogue between Alex and Astrid on some of the issues that you have to deal with every day if you're a working parent. So I'm going to start with Astrid, who's going to talk a bit about leave issues.
Thanks, Laurie. Thank you, everyone, for attending today. Again, my name is Astrid Reyes. I'm a legal fellow at A Better Balance, which is an organization that works at the national level, but is based here in New York City. And basically what we do is we fight for policies that protect workers from having to choose between caring for themselves and their families and maintaining their economic security. So a lot of our work does focus around paid family leave and medical leave, sick leave, and sick time generally. So what I wanted to talk about briefly today is 2 different forms of leave that might be available to workers here in New York. One is the Federal Family and Medical Leave Act, and the second is New York State's Paid Family Leave Law. So starting off with the FMLA. The FMLA is a federal law that's designed to help parents and other caregivers balance their jobs and their family care responsibilities. But the law doesn't actually cover all workers or all caregiving situations. So we're going to talk a little bit about eligibility requirements under the FMLA. So what the FMLA provides is it gives covered workers the right up to 12 weeks of unpaid, job-protected time off to address their own serious health needs, to bond with a new child, which includes an adopted or a foster child, to care for a seriously ill or injured family member, or to address certain military family needs. So when I say job protected, what I mean to say is that basically the law gives workers the right to return to work after taking leave, either to the same or a similar position. So in order to be eligible under the FMLA, you have to work for an employer with 50 more employees within a 75-mile kind of radius of your workplace. You have to also have worked for your employer for at least 1 year, and you have to have worked at least 1,250 hours in the past year. So that's the FMLA. That's sort of the federal law that is available to a lot of workers, but again, not to all workers here in the country. But New York actually has its own family leave law, and the great thing about it is that it's a paid family leave law. So it means that workers get to be compensated for the time that they are on leave. So this law has been in effect since 2018, but it's actually recently gotten some really important updates, and the full rollout of the law has happened this year in 2021. So what this law does is that it it guarantees workers paid job protected time off to bond with a new child, again, including an adopted or foster child, to care for a seriously ill family member. And this includes children, parents, parents-in-law, spouses, domestic partners, grandchildren, or grandparents. And it also allows workers to take care of certain military family needs. So the law actually is pretty broad. It actually covers almost all the private sector employees here in the state, regardless of whether they work part-time or full-time, and regardless of the size of the employer. So employees will be paid regardless of how many employees work for the company itself. Something I also want to note is that citizenship and immigration status do not matter for the purposes of New York paid family leave, so that doesn't affect coverage. Most workers can take leave when they've been employed for 26 weeks, so about 6 months. And this year, workers can take up to 12 weeks of paid family leave and receive 67% of their average weekly wage, up to a cap of about $971 per week. So what the law offers, in addition to all of these benefits, are also a couple other things. So the job protection element, so that means the right to return to work after taking leave, as well as wage replacement, like we said, the right to receive a percentage of your average weekly wage while you are on leave. You also are protected from discrimination and retaliation in the workplace. So you have the right to not be punished or threatened for asking about taking leave or using your paid family leave rights. And you also have the right, if you already have health insurance coverage, you have the right to keep getting that insurance on the same terms while you are on leave as you were while you were working. So in terms of these two laws, the FMLA and the New York paid family leave law, they do overlap and interact, but basically what you need to know is that if you're covered for purposes, if you are taking leave for purposes that are covered under both laws, under both the FMLA and New York paid family leave law, this means that you can be required to take time under both laws. This means that your leave will be taken at the same time concurrently. So you're kind of running the clock under both laws. But that's where I want to leave it for now, just to give a brief overview of these two laws that we'll be discussing today, in addition to a couple other laws that are relevant here in New York State.
Thank you. I think I'm gonna jump in and
thank you, Alex. Thank you. On to Alex.
Sounds good.
So I wanted to throw a third thing in there, which is disability. And before I start, I want to say, I work at Berke-Weiss Law as a senior associate. We represent employees and employers, but we've also started something called the Pregnancy Project, which we've been running for the past few years, which is really about educating people on their rights in the workplace. Because Astrid just gave a really excellent explanation of these laws, and they're complicated, right? And people don't understand them. People meaning employees when they're pregnant and or have issues where the family is ill and they need to take care of them. And also employers don't necessarily understand them. And so I want to just add something to what Astrid was saying, because the thing is, when someone is pregnant, the first question is, how much leave can I get? Like, what do I get to do? How much time am I going to have with my child? And is it going to be paid? So as Astrid explained, under the FMLA, the federal law, that's our only federal law relating to caring for another person. And it's unpaid, right? So just to remind everyone, I think I've spoken to enough pregnant women over time who truly don't understand, like, there is no federal entitlement to be paid while you're taking care of your new child. That's where the New York State paid family leave comes in. But we are talking right now, they're both 12 weeks, right? And under FMLA, if it applies to you, you can be required to take other leave that's available to you during those 12 weeks. So if you have vacation, if you have sick time, if you receive disability, because when you give birth, generally speaking, people have disability benefits. They either get those benefits through New York State disability, which is applicable to all employees in the state whose employers pay into it, or sometimes the individuals have disability benefits through their work. So sometimes employers offer disability that is more beneficial to the employee than the New York State disability. So when you have your child, if you apply for disability from New York State, the payment is $170 a week. Under some private disability benefits, those payments are a percentage of your earnings. So you might get more. So I mentioned disability because generally when somebody gives birth, they do use disability, but they don't necessarily know how little it pays, right? So under the FMLA, you can be required to use your disability during those 12 weeks. Under the New York State paid family leave, you cannot take your disability at the same time as your New York State paid family leave. And that's because the paid family leave is supposed to be about caring for another, not caring for yourself. So what does this mean? It means that it might elongate the amount of time that you have to be out of the workplace, but it doesn't necessarily increase how much money you receive during that time. And I think what really trips everybody up, I think, is when everything's working together, right? So you got your 12 weeks. This is my scientific version of 12 weeks. You have your 12 weeks of FMLA. You have your 12 weeks of paid family leave. And as Astrid mentioned, if your employer has a policy, you can be required to put them together. But if you have disability and you can't use disability for paid family leave, but you can use it during FMLA, that creates an overlap, right? So it does elongate the period of time that you might have to take leave by about 6 to 8 weeks. Because when somebody gives birth, generally for a vaginal birth, it's 6 weeks, and for a C-section, it's 8 weeks. So that's the craziness of leave. And I think that part of what's so important about what people need to understand is you don't need to be told, it doesn't matter what your employer's policy is, right? Some employers do have policies for parental leave, and that is something that you should be aware of in your handbook or otherwise. But even if they don't have a policy about it, this is the law, and you can know if the law applies to you, and you can go to your employer with resources from A Better Balance. They have excellent resources to help you advocate with your employer. Or New York State has a paid family leave website, which allows you to go and you can show your employer, like, this is what I'm entitled to. What are we doing here? And when you apply for New York State paid family leave, your employer has to sign something, but you're applying to the insurance company that the employer has enrolled in. So they don't get to decide whether or not you're eligible to take leave. The insurance company decides. And if you meet one of the reasons, they're going to allow you to take it. And then you are job protected. So job protected doesn't mean that you get to go back to do the exact same job, the exact same schedule, but it does mean that your employer is on notice that they can't just say, oh, we hired someone new to fill your role. That's not allowed during your protected leave period. So I hope that wasn't confusing more than it is just confusing. But those are kind of the overviews of leave relating to pregnancy or caring for another. Now, we're going to touch on this more. COVID obviously has changed the reasons that people might need to take leave, expanded the reasons why it's hard to be in a physical office if your children are homeschooling, or if you have health concerns. But there aren't perfect protections for employees, and we'll talk about that more a little later. But I think it's important. I'm just going to quickly explain the term reasonable accommodation and how that impacts pregnant people as well as people dealing with their own medical illnesses. So the term reasonable accommodation is a term of art in the law. That means it has a specific meaning. And the general requirement is that employees who have a disability, and pregnancy counts as a disability in this context, they can request from their employer some sort of shift in their work. So they still need to be able to do the job at hand, but they can request breaks. They can request a shift in their hours. They can request a new office chair or time to go to the doctor. So people can even request remote work. And that request process is called the interactive process under the Americans with Disabilities Act. And then if you work for an employer in New York, they also have an obligation to engage in a cooperative dialogue, which is essentially an even stricter version of the interactive process. So if you are someone who is pregnant or has a medical concern, and your employer knows because you tell them, or should know because you're walking around with 8 months pregnant, then they have an obligation to provide you with some form of reasonable accommodation. So you make a request to them, I need to be able, I can't do this commute anymore. I can't come into the workplace. I'm too pregnant. I can't walk. My doctor said I need to be on bed rest. Can I work remotely? They don't have to say, yes, you can work remotely, but they are required to explain to you why that might not work and talk about what else could happen. Maybe you can't work remotely, but we can shift your hours. That process in New York City, employers, they're supposed to put in writing, why is it an undue burden to them as an employer to offer you what you need? And this concept of reasonable accommodation is a really important tool, because if you use the word reasonable accommodation at work, what you're telling them is, I have a sense of my rights and I'm advocating for myself. I'm going into a process that has legal meaning. And while we're talking, you should know I have some awareness of this and you better follow the rules, right? So unfortunately, and I don't want to overcomplicate things, but unfortunately, you cannot take a personal reasonable accommodation to care for another person who's ill. So you can't be accommodated because your child's out of school or their school is closed. You can't be accommodated because your child is or your spouse are at high risk of COVID, and therefore you are extra concerned about going into the workplace. You're not required to be offered an accommodation, but that's still a useful framework to think about your request and how you frame things to your employer and how they can work with you. So I don't know if, Astrid, you have anything else that you want to add about leave rights and accommodations, or if we can, let me know if you want to add anything else.
Yeah, I think I think we covered pretty much all of our bases. I just wanted to flag, though, that if you are, for example, trying to request reasonable accommodations under the ADA, the Americans with Disabilities Act, you do, and you're pregnant, you do have to show that you have a pregnancy-related condition or disability. Unfortunately, it's not enough just to be pregnant, but in New York State, at least, and New York City, there is a specific pregnancy accommodations law. So unfortunately, this isn't actually a reality or like a protection that all workers in the country have, that all pregnant workers in the country have, and that's something that ABB is working on pretty tirelessly and has been for the past 15 years, I think. Basically, we're trying to ensure that workers across the country who are pregnant are have the right to actually request these accommodations. And sometimes they are just as simple as, having a stool to sit on every, hour so that you can just rest your feet. And it's really sad that that's not a protection that's already guaranteed to pregnant workers across the country. But in New York State, we're relatively lucky to have, a pregnancy accommodations law, which we at ABB and just in the field, we also call or refer to as Pregnant Workers Fairness Acts.
Well, are there any further comments that either Alex or Astrid wants to make about the general framework of discrimination laws as they relate to pregnancy? I know you've covered quite a lot of ground in your discussion so far.
I think the one point is just, we've talked about this concept of job protected leave, and these two, the FMLA and New York State paid family leave, that's your only explicit entitlement to return back to the same or similar position. But, if you are still protected by another web of anti-discrimination laws. And the most important thing to be aware of is not to try and be a lawyer yourself. I think we definitely encourage people, call a better balance and apply the rules to yourself, but and let them help you apply the rules to yourself. But if you are feeling like, you're being treated differently than other people at work, and that treatment might be because of your gender, might be because you have children, might be because of your pregnancy, those are the kinds of things that should kind of have your antenna go off that maybe something isn't right here and I should talk to someone. And anti-discrimination laws, we did a whole first series kind of talking about all those laws, and it's complicated because it's based on, what is your protected status? What is the basis for the discrimination? And can you link the two? And I guess my plea is just to say, know that if you feel like something's wrong, call a resource and check, because it's lawyers, this is our job, is to evaluate these things, and it's still complicated and there's not always a quick answer. So I think, having a sense of, well, how come I can't leave early to pick up my kids, but so-and-so leaves early whenever he wants because he's friends with the boss? Well, if you're the one who's asking and they're saying no to you and they're saying yes to somebody else, that might be a reason for you to advocate even more for yourself.
I know we talked among ourselves about the theme that runs through our work as lawyers, and that is details matter. The details are really, really crucial to understanding whether you have rights or not. Is there any insights that you can give our audience into that that maxim?
Yeah, I'll answer that one, I suppose. So at ABB, I'm part of both the outreach team. So I, participate in presentations like these and Know Your Rights trainings to make sure that workers are being informed of the rights that they have here in New York State. But I'm also part of the clinic team, which means that I am actually one of the people who responds directly to callers who call our free and confidential legal helpline with questions about their rights in the workplace. And, again, as Laurie said, what we're really trying to do today is give a general overview of what this landscape looks like. But the reality is that there are so many just particularities to every law, and it really is it's really dependent on the worker's circumstances. So, there might be one small detail that might make a worker ineligible for something that they otherwise thought they might have been eligible for. This actually comes up a lot when we are discussing sick time laws here in New York City and New York State, because they have a lot of contingencies to them depending on, for example, the employer size or even how much an employer has made in the last tax year. So, I always encourage people who are attending presentations, workshops like these to just give us a call if they really have a specific question that they think requires just an actual conversation with an attorney, because that's where you'll really get a sense of what laws might be applicable to your situation and what details really matter as well. So I think that's just always an important point to make.
Okay, Alex, any further comments before we go into our Q&A phase?
Nope, I'm ready to be questioned.
Okay.
Hi, I'm Ina Plotsky, and I am of counsel to the firm of Berke-Weiss Law, and I also specialize in employment law and consulting with employers on how to best manage their employees. My focus is on teaching employers and their management team best practices in the legal environment, what you can and cannot do. So I'm going to ask Alex and Astrid some questions from the perspective of an employee. So
I just add, Ina,
yeah.
go forward, that these are our questions because they're sort of on our top 10 list of questions that we get, but you may have questions. We have one already that we're holding in reserve. And if you have any questions, please use the Q&A box.
Yes.
And I'll be following that along as Ina goes forward with Astrid and Alex.
Thank you. Okay, so I'm an employee. When do I have to tell my employer that I'm pregnant?
I can start and then Astrid, you can jump in. So I think this is a question that we get a lot, and there's no one answer. The only requirement in terms of telling your employer is under the FMLA and the New York State Paid Family Leave Law. You do have an obligation, to give at least 30 days notice for a planned leave. So having a child, it's going to happen. You are supposed to tell them within 30 days of when you expect to go out on leave. I don't think that, generally speaking, we generally advise people, and we know it's difficult, but when you tell your employer that you're pregnant, whether that's your direct supervisor or human resources, the point is that we want to kind of say, I'm really excited about this thing happening in my life. Here's when I'm going to be out. I'm really excited about this job. Here's what I think how it's going to work. And I'm excited, tell me what you need from me, right? You want to be proactive because unfortunately, sometimes employers, they pay you to do a job and it's stressful. It's another thing. You're going to be out. What's it going to look like? Oh my God, you want to put them at ease. And you should know that in fact, there's a lot of research that shows that it's better financially for employers to not have turnover, right? So employees who leave and come back, they perform well. It saves the employer money over time. So that's kind of, you want to have that attitude, and it's hard to have that attitude, especially, I know that while people have been working remotely, there's been a trend of kind of announcing pregnancy much later because the benefit is you don't see anyone's stomach. You can just focus on them and their work. But telling your employer, oh, by the way, I'm 8.5 months pregnant and I'll see you in 4 months is probably not going to set you up for success. So I think that, there's no strict timeline, but you want to do it earlier than the very end. And if you have a medical concern, right? If you are having extreme morning sickness, if you need to go to extra doctor's appointments, if you might have to be on some period of bed rest, you're going to want to request a reasonable accommodation, and you're going to need to tell your employer about your pregnancy as the basis for that request. So sometimes it's protective to tell the employer, but not always. And I think caution against just kind of coming into work with your sonogram and being like, I'm so excited. And then, it's helpful to kind of prepare and think and understand, okay, which laws apply to me before you make that announcement, because the reality is it's challenging. And I'll, Laurie and she's my boss and my mom. I have a 2.5-year-old. We have a pretty small office, right? Obviously, when I announced my pregnancy, she was thrilled and excited, but, she was also wondering, and as was I, how is all this work going to get done when you're gone? And so I think acknowledging that that's a piece of the conversation, but doing your best to put on your best face for your employer. I don't know if Astrid, you see anything else that comes up.
No, I think that's perfect. Yeah, I think, general requirement is obviously to give 30 days in advance. And then, you know, otherwise, like if it has to, if you need to take leave for, you know, a medical condition or a sudden injury or illness, the requirement is generally to do so as soon as practicable, which just, you know, means to do so as soon as is reasonable and possible. There are a lot of different kind of factors that go into determining what practicability means, but you know, as Alex said, really, it's just about kind of being as transparent as possible about the, you know, about what you need really in that time. But I think we're also going to talk about the timeline of requesting
So that was my
family leave as well.
You know, it's interesting as you pointed that out, because I've seen it in COVID that employees tend to hide their, you know, not disclose their pregnancy much later than if they were in the workplace, so that if they're working remotely. So it's an interesting thing to think about. So when do you, at what point do you actually file your paperwork, apply for PFL or FMLA?
Sure. So I can just walk us through quickly on what this looks like for the purposes of PFL, at least. When you, let's say that you know, you're pregnant and you know that you're going to be taking leave, and let's say you want to give, I don't know, you want to start the process maybe 2 months ahead of time instead of 30 days in advance. And so you let your employer know that you're going to be taking leave. And then what you have to do is, you know, this was mentioned previously already, but basically you have to get in touch with your employer's family leave carrier. So what this would look like is asking your employer, you know, who it is that their carrier is, or looking it up yourself. There's an employer kind of insurance carrier search page on the state's workers compensation board website. So you could look it up yourself to see who their carrier is. You could also call the New York State Paid Family Leave hotline, and they can help you figure out who your employer's paid family leave carrier is. So at that juncture, what you would do is you would get a claim form. So basically, you know, you would be asked to fill out the form explaining why and what type of leave you're going to be needing. And this is a form that you should be able to get like through your employer's insurance carrier as well. So what happens then is that you are responsible for filling out the employee section of the form, and then you have to hand it to your employer so that they can complete the employer information. And they are actually supposed to also return the form to you within 3 business days of having received it. Then you will have to get, you know, documentation related to the leave that you'll be taking. So that's the application calls for the right type of documentation, which you're supposed to provide. And then you know, the application is complete and you send it back to the insurance carrier. So what happens then is that your employer's insurance carrier either has to pay or deny your claim within 18 days of receiving the application. And they also have to let you know if there are any issues with the application so that there aren't any holdups in you receiving your benefits. You also don't actually have to wait to start your leave before being approved. But it's, you know, it's important that if you don't actually hear from your employer's insurance carrier within 18 days, you should reach out to us at A Better Balance so that we can help you sort out what's going on. So that's the PFL side of things. Alex, do you want to talk about the FMLA process?
One question. So your employer is under no obligation to actually provide you with the form. It may fall on you to have to find that form.
Yeah, so, you know, workers have to be proactive. Employers should be letting their workers know that family leave is an option, you know, when they start their employment. But the actual process of getting the claim form has to, again, has to happen through the insurance carrier and worker. It's kind of on the workers to do that.
Yeah, and I think for FMLA, because you're not being paid, you're generally applying to your employer and they will have a process to apply for that leave. And I think that Astrid's point about being proactive is really true, because we also recommend, like, you have to kind of you keep track. Where are your documents? Who's got what where? You don't want to give your one copy of anything away because, you know, for real reasons or just because of confusion or whatever, things get lost, and you're going to be the one who's wanting to be paid your benefits, and you're going to be the one who cares the most about that. And so it's a good idea to keep track of when did you email things, and where are those documents.
So is there any situation under which your employer can say, no, you can't take paid family leave? What do you do? And what do you do if your employer does?
Well, I think there's actually a point, this reminds me of a point that we didn't make as clearly as we should have, which is that one of the real benefits of paid family leave is that it's supposed to be employee directed. So you are supposed to be able to tell your employer, so let's use for having a child. Within the first year of having a child, for birth parents and non-birth parents, you can take those 12 weeks of leave. And let's pretend for a second, because so many places are not covered by the FMLA. So I'm just going to throw the FMLA aside. It's not related to this conversation. So you're only entitled to paid family leave. You have 1 year to take those 12 weeks, and you might choose to take them every Friday for 60. I'm doing my math on the fly, which is not a good idea, but you can tell your employer when you want to take them. Now they can say to you, you know, why that's going to be a challenge for them. And it might not be a good idea, you know, politically in the workplace to put a lot of demands on the employer if you think they're not going to help with that. But I think you are supposed to be able to tell them how you want to use it. And that's a really big difference from the FMLA, which, as we talked about, kind of requires that you use everything at the same time. Another important factor for paid family leave is you can't be required to use your vacation and sick time at the same time. You can choose to do so if you want to receive your full pay benefit, but you can't be required. And as is the theme, you know, the FMLA went into effect in 1993. And I just saw a survey about how few managers and employers truly understand the FMLA. So the level of confusion here is really high. And I think that coming from the perspective of using resources from A Better Balance, from the New York State Paid Family Leave website, to have a shared conversation with your employer is gonna serve you well, because sometimes there's discrimination and sometimes there's just real confusion.
So how do you know when there's discrimination? So what do you do if you think you're being discriminated against?
Actually, before we turn to that question, I just wanted to mention one more thing. So again, you know, at A Better Balance, we tend to actually speak to a lot of low-wage workers who, you know, are having issues with accessing New York paid family leave, and something that they, you know, oftentimes it won't be so much my boss won't let me take paid family leave, more so than my boss says we don't have paid family leave, or we don't offer paid family leave. And so I wanted to really flag that as well. If your employer is saying that, the first thing you should really do, again, just as general kind of recommendation, check your pay stubs and take a look to see whether there are New York paid family leave deductions there, because that is one way to confirm that that you are actually contributing to New York paid family leave, which is completely employee funded. So that is, you know, something that I always, you know, let callers who reach out to us know, because that is something, you know, unfortunately a lot of employers just say, you know, like, I have no idea what you're talking about, like you don't have those rights. But that's really a way to kind of just confirm, like, well, I know that I'm covered because I have been paying into it, you know, for 6 or more months at this point. But if if in reality your employer is not covered, like has no insurance carrier for paid family leave, and they don't self-insure, you actually have the right to receive benefits through something called the special fund, which is operated by the Workers' Compensation Board here in New York State. So something that you can do is actually reach out to them about it, and that will also put the Workers' Compensation Board on notice that your employer is not carrying paid family leave, which is something that they want to know, because again, this is the law of the state, that employers have to carry paid family leave. And I guess in terms of the discrimination question, this is something that Alex already brought up, but basically, and again, this is something that I ask our callers as well when they have issues around, potential pregnancy discrimination, is whether they have seen that their coworkers are being treated or given sort of accommodations or, given leave time that they have been denied. And I think that that's really important and actually kind of difficult to do, especially during this, for workers that are working remotely. I have a lot of callers who started their jobs remotely and they don't know anyone else at the office, and they don't know if they're being, treated differently or disparately to their coworkers. And so, it's again a sign of the times, and it's something that we have to navigate. But generally speaking, we do try to seek comparators, which are just, people who might be in similar situations, but were treated differently than you are, or being given, benefits or just privileges that you're not being afforded.
Yeah.
Actually, can I just add, there's a question that was raised, if I can sort of summarize it as I understand it, and we're not giving specific legal advice today, but to this point, if I've been asked if you requested a reasonable accommodation due to your pregnancy and you got a negative reaction from your supervisor, and then 2 or 3 years later, there are layoffs due to COVID and you were laid off, how do you connect those dots? Is there a way to connect them? And, are there rights that you've got in that situation?
Well, I think that question brings up a lot of relevant points, right? So in talking about how do you recognize discrimination, and are you being discriminated against? Unfortunately, your boss doesn't have to treat you nicely. Like, nobody has to be nice. And if someone, especially if you have a supervisor who's really just yells at everybody, everyone at work, that's not discrimination, right? Like that's just being a yeller. But so I think one of the things that comes up is a lot of times people realize that they're being discriminated against or think that something's going wrong, because once they tell someone that they're pregnant, all of a sudden they can't do anything right. Everything that was fine isn't fine anymore. And they're getting a lot of questions, why are you here at 9:02? It starts at 9. Well, I don't know, because we always come in between 9 and 9:10, but that didn't matter until I told you I was pregnant. So I think that those kinds of questions, again, that's the antenna that I'm suggesting that you should apply. If you've told someone that you're pregnant, or it seems clear that you're pregnant, whether or not you've told anybody yet, I think you want to be aware of, are things happening that are different, right? Are people reacting to you differently? And this question of, asking for a reasonable accommodation and being treated badly by your supervisor, that's really common, right? Supervisors often are not trained in how to manage, and they don't necessarily understand what it means to request a reasonable accommodation and the fact that you're entitled to one, right? So I think that in that sense, having continued conversations with HR, if your supervisor is treating you badly, or even saying things like, why are we doing this? Why do you need this? Even questioning you, that can be a negative thing. But in terms of the link, right, generally speaking, in the law, you need to have some time, some temporal proximity, right? So telling your supervisor that you're pregnant and being treated badly, and then ultimately being laid off 3 years later, that's not going to have the temporal proximity. It's usually within 1 to 3 months. That's like a general time frame, but that doesn't mean that the initial reaction to your initial request for a reasonable accommodation, that might be an example of ways that you've been discriminated against, and there might be more examples that are closer to now. But that individual action is coupled with a termination much later, those are not going to connect.
Thank you. Let's just move it a little bit. What if I am breastfeeding and I need accommodations for lactation or, pumping on at work? What does my employer have to do for me?
Yeah, so I can take a stab at that one. So again, here in New York State and in New York City, we have some pretty decent protective laws for workers who are breastfeeding. And in New York State, generally, workers have the right to both time and a space to pump at their workplace, and it has to be a private space and it cannot be a bathroom. So that's really important to note. But actually here in New York City, we have some additional rights. So workers who need to pump at work, breastfeed at work, also have the right to an electrical outlet in the pumping room. They also have the right to a table or a surface where they can, put the pump and also to a chair so that they can be seated. They also have the right to have access to a fridge and running water nearby. And their employers are also obligated to give them the lactation room policy. So basically just, the rules for using the lactation room. I do want to just caveat that for this New York City kind of breastfeeding law, the rule is just that employees have to be employed by an employer who has 4 or more workers for the law to apply to them. But they still have the broad protections as well of the New York State law, which is really helpful. Again, it's just helpful to have both like a New York State and New York City law to play with if you're covered under both. Is there something else that you wanted to mention, Alex?
No, I think, people often have, this is another area where employers might not recognize what rights they are supposed to be providing. And I know a lot of people, certainly in the healthcare field and other fields where you're traveling, right? If you're working and your work is not just in your office, they don't necessarily need to give you access to a place where you are. So if you're out doing sales, like, you might need to use your car, in which case you might want to get one of those plugins for a pump in the car. So this is another area where, women do have rights, but you have to be really forthright in asserting them. And I always like to just throw out this little tip because I'm surprised. Someone told it to me when I had my son, and it was really helpful, that people often are stressed because you do have break times, but it takes a long time to pump and to clean everything, whatever. You can always put all of your pump supplies in a plastic bag and refrigerate it and clean it at the end of the day. Just a little time-saving tip.
So what happens if I have a child and their school suddenly unexpectedly closes because of COVID, or they are quarantined because of COVID, and this is not something that enables me to give notice and file paperwork, and maybe it's not something that's long enough that I need to actually apply for leave? What are my rights here vis-a-vis my employer?
So this is a question that we've been getting a lot, obviously, over the last year. And just, you know, our work at A Better Balance really focuses on, you know, family leave, pregnancy and breastfeeding accommodation, sick time, just basically ensuring that workers have the time to take care of themselves and their families. And COVID has obviously just, you know, just completely transformed our world and our reality. And something that happens is, or that a lot of callers call us about, is the fact that they need to stay home to be with their children who are learning remotely. And this means that they cannot, you know, go into the office or go into work physically. And, you know, I wish this is one of those places or one of those questions that is really hard for me to answer, because I just wish that we had better answers, more solutions for parents who are, you know, who are taking care of their children, and who need to be home to do that, but are also worried about losing income during that time. And, you know, unfortunately, there just are not a ton of really great options at this point. So if you are an employee here in New York City, it's actually, you know, one thing that you could do is actually take your sick time under the New York City Paid Sick and Safe Time Act to take care of your child. But granted, the law only requires employers to give up to 40, or if you work for a large employer, up to 56 hours of paid sick time per year. So that's not, you know, that might cover a week, but unfortunately it's probably not going to last the entire length of the school closure. Last year, we did have a law called the Federal Families First Coronavirus Response Act, which is part of the CARES Act, and that, you know, that law actually did expand FMLA to allow for workers to be able to take family leave to be at home with their kids who were learning remotely. But unfortunately, that's not something that is carried over into this year. So, you know, in a lot of circumstances, at this juncture, I suppose your employer may decide to opt into some of these provisions, and if so, they might be eligible for tax credits, but, you know, it's just not an obligation anymore, and that means we just don't have anything to really bind these employers to you know, to kind of watch out for their employees, who many of whom I think are, you know, kind of living through this very difficult period of time where they have to figure out how to both support their families while also being at home with their kids, because there's no one else who's going to take care of them. Again, I really wish we had better options, but we're always looking for people as well, like, you know, passionate advocates, people who can speak directly to this experience, you know, to help us advocate and to help us fight for, you know, pushing to push for better policies, really, at both the state and the national level. Something I do just want to flag, though, is that if your child has a specific and personal mandatory or precautionary order of isolation or quarantine from the state, then that means that you may actually be able to take either New York State emergency sick leave or even paid family leave and receive paid family leave benefits during that time. But again, that doesn't cover just the general circumstances of school or daycare closure. It really does have to be a situation in which your child received a mandatory or precautionary order of quarantine in order for you as a parent to be eligible to take that time and receive those benefits. But again, it's a sad state of affairs, really, that we're in. So if you want to, you know, fight for better laws, better policies, like, please let us know.
Well, that's a little bad news, Astrid.
Yeah.
Over to Laurie now for your questions.
Right, there are a couple of questions that came in both before and during that I wanted to raise, and I just point out this is going to be the final questions, and we've got to be succinct. And that is, we have one question about someone who goes to family court from time to time and is concerned about, they report that to HR, they tell HR that they're going, but their supervisor is nosy and wants to know what's going on. Do we, are they protected from the nosy supervisor, and is going to HR enough? And I'll give you the second question so you can jump in on that as well. And that is, oh gosh, I've lost it. Oh, anyway, I guess I'll give you the second question later because I need to find it now. Go. So why don't you take the family court section, whoever wants to go there.
Sure. So this one is a bit tricky because basically, in New York City, we have the New York City earn, safe, and sick time law. And basically what that means is that workers, again, are able to take paid sick time or just protected sick time under the law. But the additional element is the safe time aspect of it, which is actually a really, I guess, interesting kind of part of the law that allows workers to take their sick time to use it for other, matters, including purposes such as, kind of domestic or responding to domestic or sexual assault or a family offense. And so this question is a bit tricky to answer because it doesn't seem like there's really a family offense taking place here. We would obviously need more details. And again, this, the general disclaimer that we're not giving legal advice during these presentations. We're just trying to give some general information about the law. But in instances, for example, where let's say that a person has to go to court to file a restraining order against their partner, and they need to take time, a day to do so. That is a purpose that would be covered under the law, and that is something that they could actually take their sick time for. And if so, they wouldn't actually need to provide their employer with any kind of documentation unless they are taking 3 consecutive days off. And if so, and at that juncture, then their employer might be able to request either a medical note or a legal services note. But otherwise, your nosy employers really don't have the right to be so nosy unless, again, there are 3 consecutive sick days being used by a worker. But this is the kind of question where I would say, give us a call. Let's talk a little bit more concretely about what your circumstances look like, and maybe figure out if New York City's sick time law might help you here.
That's helpful, Astrid. Well, I think our last question actually reminds us that not everybody works in an office. In fact, many workers in New York City work in the hospitality industry, in restaurants, and all of us know how really devastating COVID has been to that employment. So are there particular rights that parents have who work in that industry, either because of COVID or otherwise, that we should know about?
I don't know of particular rights. I think that, you should know that New York State these laws apply to the hospitality industry as well, right? Whether or not your supervisor wants them to. And I know that there's kind of a question was raised about safety issues and COVID and hospitality industry. And I think, that's a little too much for us to handle right now. But again, thinking about the request of reasonable accommodation and what is safe for you in the safety context, that's another great reason to reach out and get some more information.
Okay. So I think our time might be up, Leslie.
I think so. I want to thank all of you, all of our panelists. This has been really educational, very informative, and I know these are really timely subjects right now. So if anyone has a further question afterwards and your question wasn't answered, you're certainly welcome to forward it to me directly. at lkraut@commonpointqueens.org. And I would be happy to forward it to, probably first I'd forward it to NILAG, New York Legal Assistance Group, who we partner with, who does have employment attorneys there. If for some reason we need additional assistance, I'll reach out to our panelists here. I want to thank our panelists and our attendees. And for all the people who attended today, if anyone has future topics that you're interested in having us find speakers for on any topics at all that you think can be helpful, please let us know, and we're happy to try to set that up. Wish everyone a great day.
Can I say just, Leslie, you are going to be supplying a list of resources to the attendees, is that right?
A list of resources from today's seminar?
Yes, or the same resources apply, people to contact, government agencies, how to get in touch with A Better Balance, etc.
Sure, absolutely. Yes, we'll send that out this week. Okay.
And we did, Common Point is going to make available the seminar that we did last week, which addresses the broader topics of employment discrimination and your rights in the workplace, which might go to answer some, because we did talk about safety issues last week. So they will be making that available, I believe, on Facebook. So check it out if you have more questions of a broader nature as well.
Okay. Thank you very much. Wish everyone a great day. Bye-bye.
Thank you.
Thanks, everyone.